Yeah, I think it's all good.
Well, how about we test it before we put it on the screen?
That's a good idea.
Is sharing your screen.
Yeah. You can hide that.
Let's just hide that.
Yeah.
Hide.
Great.
All right.
Just need to send a signal out to the projector. It's already
Forward, backwards,
Okay.
forwards.
Is it working?
Yep.
Okay. Great. Yeah,
All right.
we're ready to go.
I'm good to go whenever.
I just need to
Oh,
send
I'm
a signal.
sorry. I forgot about that. We'll do that right now. Thanks. That's totally my bad. There we go.
There's no sound, so we mute that.
Okay. Sure could.
Here's your one. Right there.
Oh, are you going to hold it? Yeah. Okay. Welcome everyone back from break. Really quick before Paul Tonks speaks to us, we have a lot of people coming in still to this conference, and so we would really appreciate it if you were on the ends of your row, if you could scoot in so that as people come in, they can see where an obvious empty, they can see where an empty seat is very easily. We appreciate that. Paul, very entertaining speaker. If you've ever heard him, we're so excited to have him here today.
Wow, thank you. That's an introduction. How is everybody today? What a great looking group. I mean, come on, this is GRAMA. See, I have the unique privilege of today of having two bosses here at the same time. I have my division chief, who is Susan Eisenman, and I have my wife, who is a Dr. Delaney Tonks, or I guess I should say doctoral candidate, Dr. Delaney Tonks. But between the two of them, they gave me two different things to say. Susan wants me to make sure that I am as legal and as straightforward and those kind of GRAMA type things. My wife wants me to be funny. And if I'm given choice between the two, I'm going to go with my wife. So I'll probably do a lot more funny. But anyway, 2016 legislative updates to GRAMA. I'm coming off a cold, so this might be a lot of fun. We'll see if my wife gives the presentation by the end. Now, I love Rosemary's idea. Fun. Let's talk about GRAMA all day. Rosemary, I'm not quite sure your idea of fun, but okay, some people it might be it, but yeah, we'll see how this goes. But we're doing 2016 legislative updates. If you were here last year, I also talked about it then, and so you might have some of the same jokes, unfortunately, because when I think of legislative updates, yay. Why are we doing this before lunch? I can't believe they got a lawyer doing this. And yeah, it's just way too much excitement for a Friday morning, no less. But we'll try to get excited, because this is really exciting, legislative updates, and we'll keep it interesting for you, because if you can't remember what happened during the presentation because you slept through it, you're not going to get anything out of it. So that's always been my idea. So a little bit about myself. I'm an assistant attorney general. I have been assigned counsel for the Division of Archives since 2008, and also the State Records Committee. I've been practicing law actually since 1996. I was a staff attorney with the Ohio Court of Appeals back from 1996 to 2002. I actually worked in the Attorney General's office for the state of Ohio for 2.5 years. I was in private practice for a little while, and I have been with the AG's office now for about 8 years. And I currently represent the Auditor's Office, Department of Administrative Services, the Division of Finance, Division of Fleet Services, and also the Office of Administrative Rules as well. And with those different things, it's so funny. I think to myself, is GRAMA hard? I think GRAMA's easy. Of course, I got 3-year JD, 8 years archives, and all those state records for me, but you get to it eventually. It's kind of fun. The most important thing about myself, I worked at Disneyland. I shot hippos and I crashed trains, and that was fun. When I was, during summers when I was in college, I worked at Disneyland, and yes, that is me, probably about 60 pounds ago, in front of the Big Thunder Mountain. So a day with GRAMA, this is exciting stuff we're going to have, the annual spring conference, but I do note it's April 1st. And so that just presents a great opportunity to talk about what I think is the greatest April Fool's joke ever. How many of you know who this is? I'm going to be really impressed. Nobody. Oh boy. So this is Sid Finch. This is a Sports Illustrated article from 1985, The Curious Case of Sid Finch. In this article has a copy of a scouting report about Sid Finch. And they say such things like, unbelievable fastball and control. You got to see this. He never played, no joke. He could be the phenom of all time. And we should start him immediately at the majors. He's only 6'4", 170 inches, but oh, by the way, he throws 163 miles per hour. The great thing about this is that they also added some other interesting factoids. He's Sid Finch because he's actually Hayden Siddhartha Finch. He only wore one shoe while he pitched, and that was a hiking boot, and he was barefoot on the other one just because that was the best way to do it. He studied with Tibetan monks, where he learned yogi mastery of mind-body. He was trying to decide whether he was going to play French horn or play baseball. It was a really tough decision for him. And did I mention, by the way, he throws 163 miles per hour. For those of you unenlightened about baseball, the fastest pitch ever thrown is 103 miles per hour. So the person that wrote the article thought it would be pretty obvious to people that this is not true. They did put in pictures. They show him playing the French horn. They show the Mets players coming out of the batting cage. I can't believe he's throwing it this fast. And the guy looks kind of gawky and geeky. And actually, he was a teacher. And then he has the catcher there with his hand hurt because he threw so hard. And then so you have the actual front cover of the Sports Illustrated. It is April 1st, 1985. That should have been your first hint. The second hint was at the top of the article there. It says, he's a pitcher, part yogi, part recluse, impressively liberated from opulent lifestyle, deciding about yoga and his future in baseball. And if you took the first letters of every single one of those, you come up with Happy April Fool's Day, a fib. The great thing about this was, some people believed it. He was invited to Good Morning America. He was, the New York Times wanted to do an article about him. There was one newspaper in New York that said, I can't believe we didn't find out about this person before. Sports Illustrated did. In any case, George Plimpton had a great novel about it. It's what I consider is probably the greatest April Fool's joke ever. I mean, really, 163 miles per hour? Studying with Tibetan monks? Go figure. But anyway, happy April Fool's Day. And for this, we're going to say the legislature didn't do much updating with GRAMA during the 2016 session. Actually, that is true. It's not an April Fool's joke. Sort of. They did a few things, enough at least to give me 30 minutes. And one of the reasons, and Susan kind of touched upon this, How many of you know what the third rail of politics means? Okay, we got one. Yeah, you're in Cedar Hills. You know exactly what third rail means. Third rail of politics. It is a great analogy. If you go to the subway system, there are two rails that the train is on, and there's a third rail. It's electrified. And the whole idea with the third rail is that that's how you get because you can't have like a locomotive engine with carbon monoxide and down in the subways. So they got to go by electricity. So they have this third rail, it has electricity. And so the idea in politics, there are certain things you don't touch. Because if you touch the third rail, what happens? You die. Death is a bad thing. I learned that in law school. So third rail in politics, as evidenced by, there was a massive remake of GRAMA in 2011. Did it end well? Those of you involved in GRAMA know it did not end well. It got through, it passed through the Senate, passed through the House, it was signed by the governor, everything's great and wonderful, but by the time everyone figured out what was in it, there was such a backlash that a special session had to be called in which the House and the Senate basically completely repealed the controversial open records law, better known as HB 477. So third rail in politics means that GRAMA's been around since about 92, 93. There really aren't a lot of massive changes made to it each year. And the reason for that is quite simple. If you restrict access to public records, you will probably be opposed by the news media and also freedom of information advocates. Now, if you want to make access easier, congratulations, you're probably going to be opposed by some governmental entities because the cost of access ends up going up. And so GRAMA is very interesting. It is a balancing act you have between these two interests. The public's right to access to information concerning the conduct of the people's business, the public's business, but then also the right to privacy for personal data gathered by governmental entities. And because of this balancing act that happens, it is a third rail. They don't want to make any changes. Unfortunately, what it has started, we've noticed, and Tricia will talk about this maybe, is that sometimes it is better to make changes, not in GRAMA, but you stick it someplace out in the code section. Because it's almost like if they say, we're going to make a change in 63G-2, it's like the red flags go up. And, the bulls come charging in, oh no, you can't change that. And so if you change something in GRAMA itself, it attracts great attention. But if you stick it in the bill and stick it someplace else in the code, and you make changes as to how access is restricted or allowed or something like that, it seems like no one notices. So thus we don't have a lot of things. So actually in 2016, we had 3 changes that were made to GRAMA. The first one involves body cameras. The second one involves FERPA. The third one involves fees, and we're going to go through each of those 3 things. Now, the interesting thing about these 3 is there might be a chance that some of you have nothing to do with any of these 3. In which case, listen to the jokes, try to enjoy it best you can. It'll be a fun time. So let us go through these and talk about these changes and how they're involved with you. Start with body cameras. This is a bill that was sponsored, HB 300, by Dan McKay and Daniel Thatcher. And it was something that was meant to try to rectify a problem because as we talk about GRAMA has to change. Susan touched on a little bit about this earlier, that once upon a time, a record was just real simple. There was a folder, it had all your information, you just kind of went to it, made a copy, and away you went. Then we had more computers, then we have emails, then we have text messages, we have all these different things, and now we're getting to the realm of, we have body cameras on almost all policemen. The great advantage to body cameras for police officers, you go to court and you can be able to just play the body camera and say, this is what I did. Because there is nothing like, say, for example, I don't know, a DUI, and you have a body camera, and you can see the person just kind of stumbling back and forth and say, look, he's drunk. It's pretty easy. It makes the case much easier. The downside is that the body cameras might pick up more information than you actually want to have sometimes. So the change was made. It's into 302.2. The following records are private if they're properly classified by a governmental entity. This is important. You always have to remember the difference between a private and protected record is private records you can have access to. If it's a protected record and you're the subject of the record, can you get access to it? You cannot. So they put it in the private section as opposed to the protected record. And under 302 and 302.1, which says the following records are private. It says, audio and video recordings created by a body-worn camera that records sound or images inside a home or residence. Okay, how limited is this bill? You probably heard about it in the meeting and thought, okay, everything in body cameras is exempt, it's a private record. It only applies to recordings inside a home or a residence. Now, they make a few exceptions. For example, depiction of the commission of a crime. They kind of want to have that public and then go into a public trial, for example. Another thing, record any encounter with a law enforcement officer and a person that results in the death or bodily injury and includes an instance where an officer fires a weapon. Kind of want to have that again as a public record. So an exception for that. I like this one. Record any encounter that's the subject of a complaint or a legal proceeding against a law enforcement officer. Well, they have to be able to defend themselves. And basically contain an officer-involved criminal incident, or it may be requested for reclassification as a public record. So how limited is this bill? Very limited. It has to be inside the house and can't be showing anything that involves a crime or something that's subject of a lawsuit. So I'm not quite sure how often they're going to be using this, but we have it. So inside the house or residence except, in other words, we just basically want to protect the privacy of the house. Now think about this. Why would that be important? I don't know. A police officer comes to ask questions because your neighbor, well, you always thought that neighbor was kind of crazy or something. They come in and they want to ask, they walk in and they look around, and congratulations, the whole inside of your house has now been taped by the body camera. And it's made public to everyone, so everyone knows exactly how the inside of your house looks. Now, I don't know about you, but I don't keep our house as clean as possible sometimes, especially when my wife is away. We worked really hard last night before you came home. Thank you, honey. You don't want that to be a public record. That's why this provision is in there. It's basically just to make sure that the inside of your house, if the police officer comes in, doesn't become a subject on YouTube for everyone to say, ha, can you believe this? Look at this statue they have in here. This is the funniest thing ever. The great thing is that we keep telling people if something doesn't pass 1 year, it might come back. And actually, I featured this in the 2015 bills that didn't quite make it to becoming a law. Well, body cameras was one of them. And that was, again, sponsored by Daniel McKay, a representative. But it was actually a little bit different. If you notice, it was instead in the protected record section, and it's a reasonable expectation of privacy. It was a lot broader than what actually came through. But it's an example of how one thing can go through 1 year that may not have gone through the previous year. Okay, second one. Actually, any questions on that? That one's pretty straightforward, right? Law enforcement, you know exactly what that means, don't you? Yes, okay. FERPA. What is FERPA? How many educators do we have here? Do you know what FERPA is? You're like, oh yeah, I know exactly what FERPA is. Well, for the rest of us unenlightened, it's the Family Education Rights and Privacy Act. And if you notice, that is the U.S. Department of Education. That means it is a federal law. It is not a Furby. It's not. FERPA is different than a Furby. So, how many of your kids actually still have Furbies? Yeah, maybe a few. But what it was, there was a change made, and this is a very magical section in GRAMA. 107, we call it the magic section. The reason why is because 107 basically says these things are not part of GRAMA. So it says, notwithstanding the provisions happening later on, this chapter, which is GRAMA, does not apply. And before, it was for protected health information, which is under HIPAA. Now, HIPAA, I guess you could say HIPAA. Why they keep going with animals and stuff for federal, I'm not sure. But HIPAA is not a HIPAA, but it is HIPAA. And so FERPA, the Education Records Protection Amendments by Representative Craig Hall and Senator Todd Weiler, is HB 288. what it does is it adds to that magic section of 107 that basically said, HIPAA is not, records that are HIPAA protected are not part of GRAMA. And it just simply said, records that are subject to FERPA or the Family Educational Rights and Privacy Act are also, this chapter does not apply. So it's a very simple, straightforward. I can't tell you about the consternation that makes to archives when all of a sudden you make what's considered state records, not records, and they have retention schedules. But this is a GRAMA conference. We will not talk about how much fun they have with that. But the idea is that if these are records that are covered by federal law, like HIPAA or FERPA, federal law applies. Supremacy clause is in the Constitution, and we will go by what's in there. Now, so the takeaway, disclosure of education records defined by FERPA will be governed by FERPA. Now, I wish I could explain to you what are considered records by FERPA, but I'm not as smart as him. Basically, we had a fun situation where the state auditor, who I represent, wanted to get some records from the State Board of Education. And I got to learn all about FERPA. It took me a long time, and I still don't understand FERPA. So for those of you that know FERPA, great. But I can't explain it. So third one, how are you doing? Oh, that's the 10-minute sign. I'm doing great. This is wonderful. Fees. How many of you worry about fees when people ask for records? We have a few hands. You don't worry about fees? We'll just pay out whatever. Well, one little fun thing I'll say about fees. Last year, they actually ran a bill and they said, we're going to basically waive fees for everything. Everything's going to be a free record. And that sounds like a great idea. And they said, okay, here's a chance to have everything go out, until the Department of Corrections said, excuse me, we have a lot of prisoners that have nothing to do with their time on hand except just make GRAMA requests, and you'll basically bankrupt the prison if we make it all free. So, but they decided to go ahead and do it. The general proposition is, a governmental entity may charge a reasonable fee to cover the governmental entity's actual costs of providing a record. Sounds simple, right? There's the general proposition. It doesn't end there. And what is reasonable? That's another question. So we're going to have to take a look at it. So generally, when compiling a record in a form other than is normally maintained, the actual cost may include, and they give you a laundry list. And those of you that provide records know this laundry list very well. You can charge for the cost of staff time, compiling, formatting, manipulating, packaging, summarizing, or tailoring the record into an organization or media to meet the person's request. You can charge for that. Because why should you be taking this extra time on something that's difficult? If you had nothing but GRAMA requests, well, you should be able to charge for some of those things. And the legislature recognizes that. The second one, the cost of staff time for search, retrieval, and other direct administrative costs for complying with the request. You can charge for that. That's a good thing. And this is all found in 203-2A. Now, remember, you can't charge a fee for some things, and the legislature makes it very clear what you can't charge for. For example, reviewing a record to determine whether it is the subject to disclosure. You can't charge for that. And you can't, for example, if an attorney has to go through and figure out, okay, this part of the record can be disclosed, this part can't, they want to be able to get a hold of the record. The time it takes to compile and put that record together, you can charge for it. But if you're trying to determine if it's a non-public or public record, you can't charge a fee for that. The second part you can't charge a fee for is inspecting the record. Can't do it for that. And this again under 203-5. Another part about fees, want to make sure all of you remember, you can't charge for the first 15 minutes of staff time. I don't know, that's kind of fun. I mean, legislature and their deep deliberation, should it be 10 minutes? Should it be 20 minutes? Let's compromise, let's go with 15 minutes, okay. And it's actually in statute, 15 minutes, not 20, not 30. Also, the time that can be charged for staff providing the record may not exceed the salary of the lowest paid employee who has the necessary skill and training to perform the request. No joke, we actually had, for the State Records Committee, one entity argue to us that the attorney that was there was the lowest paid person who had the necessary skill and training to format and put everything together. And we didn't find that very persuasive for some reason. So, can you provide a record for free? And any Milton Friedman fans, his great line is no such thing as a free lunch. The answer is, well, yeah, sure. Of course you can provide a record for free. A governmental entity may fulfill a records request without charge. You can do that if you want. But there's also an extra part. A governmental entity may fulfill a record request without charge and is encouraged to do so when it determines that. And here's the laundry list to remember. Releasing the record primarily benefits the public rather than a person. The second one, the individual requesting the record is the subject of the record or can legally request the person, request for the person. Say, for example, you have a power of attorney. And the third part is the requester's legal rights are directly implicated by the information in the record, and the requester is impecunious. Now, I want you to concentrate on that little yellow may up there. I highlight these things for a good reason. It says may. What does may mean? Besides Mayflowers, may. And this is one of those where it's legalese 101. You don't have to go to Harvard Law School, which is pictured here, to figure out. May does not mean the same thing as shall. There's discretion that is given to the governmental entity on whether or not the person can receive the record for free, even if those things were found. Now, in GRAMA, it does provide a right to an appeal, and it's under 2036. A person who believes that there has been an unreasonable denial of a fee waiver may appeal the denial in the same manner as a person appeals when inspection of a public record is denied under 63G-2-205. Basically, you have the same rights to appeal that denial of a fee waiver as if you weren't able to get a hold of a record, which means State Records Committee. We love them, except I got to update my picture because half those people aren't there anymore. Appeals can go through the State Records Committee, which is administered by the Division of Archives and Record Services. Or you can also appeal to district court. That's where you have the rights of appeal, those two places. One's a lot more friendly and nice than the other. I'm just saying, State Records Committee, they're nice people. They're really good. Council's really nice too. But the standard of review for appeal is what was changed on this. A governmental entity may fulfill a record request without charge and is encouraged to do so, and they changed when to if. Honestly, seriously, I don't think there's much change on that. But the other part is right here. It added in and said, the adjudicative body hearing the appeal shall review the fee waiver de novo, but shall review and consider the governmental entity's denial of the fee waiver and any determination under subsection 4. Now, the de novo part, this is where all the lawyers, you sit up and you take notes like, ooh, de novo, that's really important. De novo means from the beginning, afresh, anew, beginning again. De novo, or novo, I guess, kind of means new. You don't have to rely upon what was done previously. Matter of fact, it's very interesting, is that decisions for the State Records Committee, it is reviewed de novo by the state courts. Now, it says de novo, but this is the interesting part. Even though it says de novo, it doesn't mean they don't take in consideration what was done before. Even in the new statute, it kind of talks about consider the needs of the governmental entity. For example, in district court cases, in my 8 years with the State Records Committee, they have only overturned one State Records Committee decision, which then got overturned by the State Supreme Court and put it back to the State Records Committee. Even though they don't actually say it, I get the feeling that sometimes district courts look at the State Records Committee decisions and say, they kind of know what they're doing, and we're going to do this de novo, but there's going to be some deference that's given. And so when it comes to de novo review, it might be similar for the State Records Committee. So things to keep in mind on this, HB 63 has not become effective yet, so no case law, because it's never even been presented to the State Records Committees yet. And I love this language that was used in a decision by the State Records Committee, because I think this language is still going to be used even with the change in the statute, because it says 2034 encourages a governmental entity to fulfill a records request without charge under certain circumstances. But GRAMA still gives a governmental entity the discretion to deny fee waiver as long as the denial can be considered reasonable. In other words, even though it's de novo, I think there's a really good chance the State Records Committee will make decisions and just look at the reasonableness. So for example, what's an example of unreasonable? We are granting fee waivers for everyone that has red hair, but everyone else we're denying. That might be unreasonable. Everyone A through K, fee waiver. After that, forget it. That would be unreasonable. So does it really make a difference? I don't know. We'll just have to see. But nonetheless, the change has been made. So what do you really need to know? You've been here for, how long have we been here for? 20 minutes? Are we 20 minutes? Half an hour? What do you really need to know from this? My voice is about ready to go. Why didn't you provide a handout? One, well, I'm trying to save the trees, honestly. I might be lazy. That could be part of it. I did have a cold yesterday, and I put in, hopefully at this point, I still have a voice, which, yay, I do. This is good. Lemonade and Red Bull, it works. Too busy doing things with Office of Administrative Rules. That was for Ken last year. But really, not a lot of changes have been made for this year. There's some things that are very specific, but you should at least keep note of them. So, what do I really need to know? Remember that audio and video recordings inside a residence are generally private records from the body cams. Second takeaway, educational records for non-higher education institutions, because FERPA really only covers those that are basically the lower ed, not lower ed. Proper word would be public education that's not universities. FERPA, they're governed by them and not by GRAMA, and it's now in statute. And fee waiver appeals to the State Records Committee are now reviewed de novo. So, after all that fun and excitement, do you have any questions? Any questions at all? Not a single one. Susan Eisenman, do you have a question? Do I have a job after this? That's my question. No. Question.
I like to think of myself as the funny person, so I don't like in our division. So when you're really funny, that upsets me. But
I shot hippos.
Here's my question it's about the body cams, and
yes.
I'm just wondering your take on this. So clearly it now says the body cams inside the house are private unless they show commission of a crime.
Yep.
Let's just say that they do show commission of a crime. In your mind, is it possible? So now it's not private. Now it's not private under that new section. But could it be private if it showed something that was a clearly unwarranted invasion of privacy? For example, if during the commission of the crime, a victim, I don't know, peed their pants or something. Something. I'm just thinking out loud, and those in law enforcement probably can think of a lot of better things. But if something, is it still possible in your mind that that body cam could be considered private under one of the other sections, like the clearly unwarranted invasion of privacy section?
Sure, absolutely. And that's a fair question to think about. Is the body cam provision the sole part? And the answer for all things in GRAMA is usually no. There are other parts. Could you have a judge look at it and say this is a clearly unwarranted invasion of the personal privacy of the person because it is showing something that shouldn't have happened? Sure. But the key is they want to be able to have these body cam records so they can use in court for, say, a criminal case or something like that, or a civil case. So those parts, and we don't have to require them to go back through and redact in the camera. Okay, the yellow wavy thing is going. That's very handy. I like that.
I just have a clarifying question relating to where you were discussing about fees. You said we could charge for compiling, manipulating. There were all kinds of words ending in ing there. But the clarifying question is that GRAMA still does not require us to create a record where one does not exist.
Yes.
So when you talk about compiling and all of those things, we still do not have to say if they want all of our employees' names and office phone numbers put into a spreadsheet and we don't have such a character. Correct. We do not have to create that.
Yep, exactly right. Yeah, compiling doesn't mean creating. Or kind of running through. We didn't hit some of the other parts, but yes, there is that section that says you don't have to create a record. And I love this, for example, because we get this in Department of Administrative Services all the time. This question of, I want to know how many employees have done X over the past time. And we don't have a record that actually says that. They want us to go back through and look through and basically do the research, and sometimes it's news media that asks for that. We're creating a record. They're asking for information. They're not actually asking for a record. Okay, Nova, question from the top.
Okay. Earlier, Susan talked about metadata, and
Yes.
I needed to ask for my employer if there are precedents being set or legislation being drafted for metadata in documents, like if we need to start using track changes when we're creating reports and things.
Okay, two parts to that. Is there precedent being set for it? I will say yes. Other states, there's definitely been precedent because when there's an asking for the record, the whole record sometimes is actually being asked specifically, which includes the metadata. And the reason why metadata might be interesting was kind of commented upon. There may be changes that are in the document that are tracked, or in some cases you've actually had where they were trying to figure out when was the document created. So maybe, I don't know, there was a change made to the document to make it more compliant with what they want. So that's why enterprising attorneys, they ask for metadata as well. As for legislation being drafted on metadata, I'm not aware of any legislation, at least for Utah. It's got one question here, and we got another wavy thing. Okay, go ahead and say, and I'll repeat.
This is our last question.
Well, we can take two, can't we? Quickly, okay.
So question, gentleman earlier alluded to the fact that he's receiving a lot of requests from these data mining companies.
Yes.
And basically they're using our records as a marketing list.
Yep.
If, for example, we have a spreadsheet that has taken a long time to compile, and then we have multiple requests for this spreadsheet, can we charge a fee based on that?
Ooh, that is an excellent question. And this is going to go back to a certain CD problem that came for voter records that came actually through a district court. If you did it in the regular course and that you put it together, that spreadsheet, and it was just what you were supposed to do as a job, and they asked for a copy of it, you can't really charge them for what you were doing as a regular part of your job. But if you had to be able to put it together, but that's kind of getting back to your creating record, yeah, probably not. So it depends upon, did you do it as part of your regular course of what you're doing in the job? If the answer is yes, you really can't charge for that because you would have been there anyway. Okay, we were supposed to be short on time, so I'm going to do one more question and then you can ask me right afterwards. Quick question.
On body cameras, if you
Body
have-
cameras.
On body cameras, if you have an officer respond to a crime scene and this video has crime information on it, but there's also private information or, a residence or home, can you redact the private information and release the criminal part?
The great thing is since you have the video, if you have the capability to do it, great, wonderful. GRAMA doesn't require you to do it in that case because I think GRAMA is kind of thinking the capability of redacting something out of a video is a little bit harder than just like blacking out.
Exactly.
And so it's not requiring you. But if you want to do it, great, that's wonderful.
But we're
That'd
not
be a great thing
required
do.
to.
But you're not required to. Okay. Oh, Tricia, clarification.
I do.
The voice from Division of Archives from the top.
Sorry, so isn't there a requirement in GRAMA that if a record contains both public and non-public information, you're required to segregate and provide the public information?
There is that part of GRAMA. And the question is, does that actually extend to video camera, videotape? We haven't addressed that yet. So it's a good question out there. Yeah, because GRAMA, so in a document, you're required to take that private out. But I think the reason why they were running that legislation is because, do you have the capability of going to your screen and blacking out? You can't. So, all right. If you have other questions, I'm going to be here for a little bit and I can answer questions best I can. But otherwise, you've been a great crowd. Hope you enjoy the rest of your day because, a day with GRAMA, it doesn't get better than that, does it? So happy April Fool's Day and have a good day. Thanks.